15 seconds. Guidance is internal. 12, 11, 10, 9. Ignition sequence start. 6.
This is 420 Law Office Radio.
Okay, Tony, did you have fun when the client came here? Do you like to discuss medical marijuana law? Do you want to go sit on your chair? Okay, baby. Hey, what's going on? Stu Richlin from 420 Law Office, and here on the YouTube channel. Today to discuss the case of People versus Bagnani. And the fantastic and interesting thing about that ruling is that in that case I was proud to be the expert witness, and the ruling of the case lets you know exactly what's necessary to raise the defense of medical marijuana. One of my colleagues jokingly said what's necessary is, of course, to hire Stewart Richlin as your expert witness and to consult with you. In a way, that is sort of true, because in the case of Bagnani, Bagnani had consulted with me. He formed a nonprofit, and he used the forms and research that I provided him, and then it worked in court. In the end, he was entitled to the medical marijuana defense. So I took some snapshots. Let's take a look now at the case number and the front page of the case. Okay, that should be it right there. So there's the case. It's the case of Bagnani, and you can see that this decision of the Court of Appeal was certified for publication. So it is now the law of the land. And now let's take a look at the decision part that mentions my name. And as to that part of the decision that mentions my name, the case states that defendant started a medical marijuana collective because he had had an uncle who had passed away from pancreatic cancer, and actually that was the way that he learned about medical marijuana and its benefits for patients. He testified that he did not have an intent to sell marijuana, that the collective would be a nonprofit entity, and that's an important distinction, is that even when the federal government, which still holds that marijuana is a felony not subject to a medical necessity defense to grow, sell, or distribute, even the federal government's guidelines with respect to their own activities, such as the Ogden Memo and the Cole Memo, make a distinction between commercial activity and for-profit activity. And California activity, to be legitimate, should be nonprofit. And this fellow testified, and the evidence was that he had a nonprofit corporation as well as a seller's permit, that he had counseled with me, and that I had testified on his behalf about the fact that I drafted the bylaws for that corporation, and I reviewed the state law with the proprietors thereof, and that the corporation was filed using the format that I had written, and also the entity got a seller's permit. Those were the only two things that the entity had. And so I think this is a very important ruling, because sometimes judges will try to interpose a requirement that a city license be necessary in order to raise the defense of medical marijuana and get the quote-unquote good jury instruction. Here is a snap of the good jury instruction. The jury instruction under Health and Safety Code section 11362.775 is that defendant is not guilty of the charge of possession of marijuana for sale if the jury shall find all of the following. A, defendant possessed marijuana. B, defendant was a marijuana patient with a note from a physician. C, defendant was a member of a co-op or collective that cultivated for medical purposes. So, as you can see, getting through the threshold of getting the proper jury instruction will make all of the difference in the ability of a California defendant charged with possession for sale being able to get a good shake from a jury. If the judge refuses to give that jury instruction, that's pretty much going to tell you that the jury is going to convict. If the judge gives the jury instruction, you can bet that the jury is probably going to acquit. So one of the main tasks of your defense attorney, and in turn one of your main tasks if you are a medical marijuana patient or someone who's providing marijuana to other patients, is to make sure that your activity is defensible under state law if you're counting on being able to raise the defense. That's where having a good consultation from a good attorney is very important. And I'm proud to say that having now been officially sanctioned by the Court of Appeal, I think that this consultation is more important than ever. And again, as I tell people, I'll take the Pepsi challenge with any other attorney, anyone else on their presentation of this topic. Here's my corporate kit. It comes now with a little chip so that you can have some material on a soft format as well as the printed material. So I'll be very happy to get you through here for the consultation, the $500 consultation, as well as the $1,000 upsell, which is the corporate kit. And until then, I wish you very, very well. And I hope that you, if you're a patient, are feeling better, and I hope that your caregivers and collectives are treating you well. If you're a family member of a patient, take good care of that person. And if you're in support of the community, thanks. If you're still on the fence, do some more research. Find out about how medical marijuana alleviates suffering, pain, spasticity, nausea, migraine, etc., glaucoma, arthritis, and any other condition for which a California physician recommends that marijuana will provide relief. All right, take good care, and I'll see you soon.